speaking of September, I was I was thinking about a get together time, and I think it makes sense for us to do an in-person get together in September, um, after everybody's August holidays and everything, and while the weather is still nice. So expect a doodle poll in your inbox in the next few days, to try and find some dates about what will work for you. Um,
Do you
And
have a
Valerie, I'll
location?
help, of course.
Do you have a
Thank you.
location, Valerie, where you want to do it?
I was sort of thinking Piggins would be nice. That historical society patio they've got. I had a really lovely glass of wine there a couple weeks ago with a friend, and it's right on the South Park blocks. It's pretty accessible for everybody. So it's a little bit harder for our out of town folks, but we'll try and accommodate Sandy's schedule and hopefully get him up here too, and so we can see him in person for the first time in ages.
If we
Roberta.
figure out a date ahead of time, I can make it work.
Yeah, so Roberta, maybe you and Sandy can carpool up. That would be wonderful.
Sure.
Okay, so anyhow, so we'll do that for September. And then just as housekeeping, I've had a couple folks approach me about wanting to roll off maybe this fall. I think people's professional commitments have changed, and as things are ramping back up in the season, work season, I think we'll be seeing some new faces. So, just consider, I think we're going to be done with this in the next couple months. But then we have to have the chat about the corporate act too, and sort of what next steps look like. And and I don't know, Jeff, if you and the other business law people have had a chance to talk about sort of what your goals are with respect to that.
Well, again, you had a reach out from Kara Tatman.
Yeah, and she said that you guys were going to talk about it last meeting.
Yeah, and we did. I mean, we want to move forward. I guess the overall feeling is trying to work on these acts concurrently and not consecutively, just because of the amount of time it takes.
Yeah, I mean, I think the next step for the LLC Act is going to be going through and scrubbing it.
Yeah.
And making sure that we get all the feedback incorporated into what we send to Legislative Council.
Yep.
So I think after that, there's another logical break point. So there's the sort of summer fall break point that we're coming up on, but then there's another logical break point after we finish incorporating feedback into this. At which point, we may, the LLC group may choose to meet quarterly, and the corporate group could meet more often.
Valerie, I'm sorry, Jeff, I think it's relevant just in timing. One thing that might be helpful is if the folks from, Jeff, it sounds like you're working with the business section. If you could just do, it could be really bare bones, but a proposal to the Law Commission just to re-up it. Because it's a new topic, I do think it would have to go through the meeting. Right now, we're looking at scheduling a meeting sometime September, October realm. So it can be pretty bare bones. It can just kind of talk about how it's connected to the work we're doing now, but we're going to need something just to make sure they can vote on it.
Well, two things. One, I'm the chair of the executive committee, so I can twist arms. I've got the authority. Okay. So I'll get you bodies. We've talked about that. And that I think when Kara reached out, I don't know if Valerie, she talked to you about that, is that's what we were thinking, is just doing another memo to the OLC, kind of copying much what we did the first one for this act. Because there's not going to be a lot of difference in submitting that. But then, there was some confusion, I think, probably in the sense of whether this committee was going to morph into that. And thus, we didn't necessarily need to re-up the OLC. So I think fundamentally, how do we approach this? Do we treat it as completely separate work group? And thus, and submit a new memo and start the process over with the OLC?
So I don't think
this morph.
So I think it's sort of a hybrid. I think that we could keep a similar structure. Any members who want to continue can continue on it. We can keep this, if it depends on who wants to lead it. We can talk about the chair role and things like that. So I don't think we need to disband, but I do think because the topic is different enough, at least we need that memo. But it doesn't,
Yeah, and Jeff, with respect to leadership, I think that probably I should not lead that effort on the corporate side of things, because I suspect that it's going to take some time in the 2023 session for to have a couple people that are focusing on getting the final bill through. And so I think that that's maybe not entirely consistent with, doing a full scrub of a corporate act too.
But then if we do that, then aren't we really, if you're not going to chair the second act, the second work group, we'll call it, then should we just not really form a new one and, with the memo, get a new group going? And people on this, and I think it would be important for that, people on this work group would also, some would serve on the other, because the liaison factor and consistency factors of the knowledge in this group. But should we just go down the path of setting up another group, including another chair, and then just maybe cross-pollinating the groups in
Well,
terms of membership?
Jeff, I think first of all, people should consider what they want to do. I mean, I think that's the most important thing, because it is a pretty significant time commitment. And I think that also, so people should consider what they want to do. And then we should talk to the Laws Commission, see what the Laws Commission wants to do. So I think those are the two sort of preliminary steps that need to happen.
Okay, I mean, I can tell you, we've already talked to the legislative group. There are several people sitting on the EC right now that are not on this work group that are interested in participating in the next act.
Yeah, and that's fine. I mean, I think that's great, but I think that, it has to, this group and people have to decide if they want to express interest or not. Because again, it has been a time commitment. And then the Laws Commission needs to decide what they want to do as far as sponsoring this, because this does use resources from the Laws Commission. So, what the business law section says is important, but it's not entirely determinative.
Well, should I go ahead and have the legislative committee of the business law executive committee, should I have them go ahead and prepare the memo and submit it to the OLC?
Sandy?
That's totally fine on our end. And I think it would, if it could be done in the next month and a half, that'd be really helpful as I start to schedule the next meetings for the Law Commission to decide on its next projects, just so we have that in the hopper ready to go. And then what I'll do is, once it's scheduled, Jeff, I'll probably get in touch with you. Someone just to come present. It wouldn't be it would be a short presentation, but just to kind of talk about the parameters of it. But yeah, sometime, if I could get that by the end of August, I think that'd be fine.
Well, I'm actually going to be talking to Kara Tatman later this week on a matter. So, and she's the co-chair of the legislative committee. So I'll talk to her and ask her to get going on the memo. We've talked about it, and I'll give them what we used for the LLC memo and get her going on that. So hopefully we will have something to file in the next month or so.
And since Susan blinked into existence here, I suspect she has something she wants to say.
Yeah, I thought so too.
Just reinforce the conversation that's going on. I think go ahead and get a memo to the Law Commission. I think and having business law section participation is fantastic and important. I think if there's some crossover with membership from this group to the new group, I think that's really helpful for the institutional memory as to what you were thinking and how you're moving forward and some of the decisions that have been made thus far. I think that's really important. The key to all of this is that it's the Law Commission that will have the credibility. And I don't mean that the business law section doesn't, but the Law Commission has a standing relationship with many legislators, and they are looked to as the body that moves this kind of law improvement forward in the process. So I think coming up with a completely separate business law section group may not make sense. I think it makes sense to work hand in glove with the Law Commission to have this be one of their projects that has the imprimatur of the Law Commission in the whole process. And I think they have a lot of credibility, and I think we want to take advantage of that.
Well, I just, Susan, to respond to that, I mean, that was the same discussion we had with the LLC Act, and that's exactly what we're saying here. We have no intent for the business law section of the bar to sponsor this. It'll go through OLC. The other big question is just to verify, because we've had a discussion back and forth, what's the next act? Is it the corporate act? Or, I mean, what's this memo on? The corporate act, the partnership act?
I think that is something that probably bears some further discussion, but I know that Commissioner Shatterly was interested in the Partnership Act. I don't think any of the bar is particularly interested in doing the Partnership Act next. I think the bar has always expressed more interest in the corporate act next.
So I think that is true. I think one thing to consider is the Partnership Act in the grand scheme of things, a little simpler, shorter, easier
Mm.
project to just get done and then move on to the corporate act. I mean, that's something to think about. I think the corporate act is a pretty big lift.
I mean, one thought, just to be honest, is I think the goal of having the LLC Act ready for 23, I think is feasible. But I think if we can have two ready at the same time, if there is one that could potentially fit by 22, I sort of agree with Susan that could be a really good idea to pair those together. We've had success with different work groups getting a couple bills through at once.
I suspect it's vanishingly unlikely that we would have another act ready to go.
Yeah,
okay.
Just based on the time, but going back, Susan, what you said about the heavy lifting, I'm guessing, I haven't looked at it, but the partnership, the Uniform Partnership Act is going to look like the LLC Act. It's going to be the same level of lifting as we're doing now.
Yeah.
I don't think it's, because they're so similar in many respects. And then the other piece of it is going back to what Valerie said, the bar pretty much prefers the corporate stuff. I haven't formed a partnership, you guys, in years.
Yeah.
Why would I?
Same.
With the other options out there in the way of the corporate and the LLC. So, 80, I think the numbers, and I'm roughing it here, 85% of entities formed in Oregon are LLCs. The next 14% are corporations. And the remaining 1% is the other stuff.
It's the inadvertent partnerships where the Partnership Act becomes relevant.
Okay.
Where people didn't understand that's what happened.
Right. And that's a good point.
Carpet layers.
Yeah, that's a very good point, Mustin, that is. But nevertheless, if you look at it from the numbers, the logical thing, and I think most of the lawyers are feeling, so the question is, how do we bridge this with the legislature, are feeling that the corporate act should be the next act. It's the next one that's most heavily used after the LLC.
I don't know that it's necessarily an issue of bridging it with the legislature. I think it's just a matter of having some discussions with the Laws Commission. And that's why I think it's important to have the discussions with the Laws Commission, since this is their project.
Okay, because we can't write the memo and move it forward until we make this fundamental decision.
Michael?
So how do we have those discussions with them soon so we can move forward with doing a memo and moving the whole process forward?
So I can speak on behalf of Michael, do you want to go first?
Yeah, let Michael.
Well, I just wanted to make the point following on what Jeff is saying, that I think one thing we might want to look at, Jeff, in that memo, I'm on that subcommittee as well, is I think making the point to the OLC that probably the corporate act is where our Oregon statutes have the largest deficiency. We're woefully behind the country in updating our corporate statutes. And I certainly understand that the sort of the inadvertent partnership issue is out there. But again, I would use the measuring stick of deficiency is in the small number of cases where we need a statute that covers the inadvertent partnership, is our current statute woefully deficient. And so looking at those two measuring sticks, I think the greatest need is over in the corporate act. So it may be a point that we want to make succinctly but clearly to the OLC in that memo.
And yeah, so Jeff, what I would say is that you and Kara and Michael and the rest of the Laws Committee should probably take a first stab at the letter in support of what probably will be the corporate act. And then I think that, Sandy, if you could reach out to the Laws Commission and report back at our next meeting on sort of preliminary thoughts that people may have about what the next thing should be, and if they're willing to move forward with another act.
Yeah, my impression is that this group has a lot of credibility with the Law Commission. PK, the chair, is really been happy with the progress, and even going back to Lane and everyone else. So I think that whatever guidance, and I've always reported that our progress is really good and we're on schedule, and I've just been really impressed with the group. So I think that whatever decisions are made by this group in the memo, I sincerely believe the Law Commission will move forward with, and I'll help with that process. But I can certainly get an affirmative back by the next meeting. That won't be a problem.
Yeah.
At least it won't be voted on, but I can get kind of a yes, present it to us and we'll consider it type thing.
Right, so we should move forward though with the memo on the corporate act?
I think, well, it took 6 months to write the last one, so probably it would be a good idea.
Well, no, but Okay, I mean, notice we'll wait to the next meeting and hear the feedback, but we can move forward. I don't think it'll take 6 months this time because we have a template and we know what we're doing. Last
Right.
time, I don't, I
And
sure
I
as
think
heck
what
didn't know what I
I
was
think
doing.
Sandy's saying is that it doesn't have to be quite as comprehensive too. I think they just need a
Yeah.
proposal.
The proposals are short. They really, we trust the work groups to understand the content matter. It's just more topic, goals, and when we hope to be done. You know, basically that's kind of the key information.
Okay, all right.
So I
then,
would concur with Michael as well. You know, our corporate act was last changed in 1987, so it's old.
yeah.
So my suggestion is, Jeff, if you and your group want to get started on the corporate act memo now, I don't think it'll hurt, because I guarantee you, if I go back to the folks of the commission, they're just going to be like, if that's what this group thinks is the next one to do, give us a memo. So that's going to be the answer.
Okay, all right.
Yeah, and that's why I wanted to mention this, because, you know, part of that process was trying to find people who wanted to be involved. And, you know, the business law section is composed of business attorneys, obviously. But we still need litigators and debtor creditor attorneys and tax people and, you know, people from all of the groups that we've talked about, you know, our Department of Revenue folks, ideally Secretary of State. Doesn't look like they're able to join us today.
Yeah, Jamie said she wasn't able to join today.
Yeah, Summer's
but they've enjoyed being a part of these, so I have no doubt they'll stay with it.
Yeah,
Plus,
and
yeah.
yeah, but it can be a bit of a slog. So I just do want to encourage people to think about over the next month or so, do you want to continue to do this? And if not, then is there someone in your respective sphere that would be a good person to step in, either, you know, in the fall or as the new project starts up? So, okay, great.
Okay, I'll get the EC folks started on this.
Fantastic. Thank you, Jeff. Okay, so not to make a tax joke, but I think we left it at section 1031.
Actually, Valerie, could I start off with a follow-up that we had from section 11?
Oh yeah, of
This
course.
will only take a couple of minutes.
Okay, then I get to make the tax joke again, so that's great. I like that.
Excellent. So remember when we talked about section 1101, which had to do with uniformity application and construction, and some of the folks asked me to take a look at Washington's version and Delaware's version of the same section 11 information. And they had a provision, both states had a provision that says the rule that statutes in derogation of the common law are to be strictly construed has no application to this chapter, and wondered if we should have that same provision in Oregon. So I spent some time looking at that and determined that we do not need to add that same provision that Washington and Delaware have, because Oregon got rid of the rule that statutes in derogation of common law should be strictly construed in a 1985 case called Beaver versus Pellet. And so it's completely unnecessary for us to do what Delaware and Washington did. And I just wanted to report that back to the group.
Yes, thank you. No, that actually is good to know. So thank you for doing that. Beaver
Welcome.
Versus Pellet.
299 OR 664, if anybody wants the site. It's a 1985 case, which has been superseded by statute on other grounds, but that particular rule has stayed in effect as recognized by the Oregon Court of Appeals in a case called Nyatt versus Rage Wood Products.
Okay.
So.
And Teresa, I know you were gonna look at 1101 with all the edits or subsections in 1101 of the Delaware statutes with respect to Delaware. And I know it's generally covered under section 105 of the Model Act. I just didn't know if you had any other further comments. I don't know that anything is necessary after I started looking at 105. I think most of that is covered there, but
I agreed with that. I thought most of it was covered by 105, and I thought some of it needed to await our discussion to what extent we're going to allow people to get out of the duties that they are otherwise subject to under this. You know, different states have different views on to what extent you can modify duties of members and managers. And I know we had some open questions about that. So I think that if we're going to talk about this at all, we should wait until we make those decisions, because I think this would follow from that.
okay. I know that.
Awesome. Awesome. Okay, now I do feel like this entire revised LLC Act was structured in such a way that the interest exchange provision started on section 1031. So go team. Anyhow, okay, so I think this was Molson and Cliff are gonna get us started on this.
Yeah, although Cliff, I don't think I was planning to do it. I don't think you were.
Okay.
But if you have input, feel free to speak up.
Okay.
Okay.
If I had a puzzled look on my face, yes, it is.
I just have
So-
a note here for both of you, so.
I did prepare some slides just to kind of briefly set up what we're going to talk about, and again raise the question of whether we should be talking about this. So let me just share those slides briefly. These are slides straight out of my M&A course for my law school students. And as I tell my students on the first day of M&A, there are three ways to structure a transaction. And one of the simplest is just simply to acquire the outstanding equity interest of an entity, what would be a stock acquisition in the corporate context, right? And if you do that, you wind up with the acquirer owning the target entity as a wholly owned subsidiary, assuming all the shareholders of the target entity actually sell you their shares. The issue that commonly arises is you will have some number of the target entity owners who don't want to sell their ownership interest, but there's a way around that, which is that you could, as long as you have a majority of the owners of the target entity willing to sell their interest, you could structure the transaction as a reverse triangular merger, where you have the target entity merge with a newly formed subsidiary of the acquirer, in which case you get to the same place you would have gotten to with a stock acquisition, but you were able to do it without having all of the target entity owners agree to the transaction, as long as you have a majority. So that's one of the key advantages of a reverse triangular merger. What an interest exchange does is allow you to get to the same place as a reverse triangular merger without having to go through the formality of forming that new subsidiary to engage in a merger transaction. An interest exchange is essentially going to be a transaction pursuant to which the acquirer will acquire all of the outstanding equity interests in a target entity, or it could, in theory, acquire a subset of or a particular class or series of the equity interests of the target in exchange for whatever consideration the agreement between the acquirer and the target says. In the corporate context, this makes some sense because it cuts out that step of having to form a new subsidiary to engage in the transaction. You could essentially do what you could already do with a reverse triangular merger, but pursuant to an interest exchange. And like a reverse triangular merger, in an interest exchange, you only need a majority of the outstanding equity interest of the target entity to agree to vote in favor of the transaction. What makes the interest exchange concept puzzling in the LLC context is that the default rule is under RU LLC A 1033A1. The default rule is that all members of the LLC, the target LLC, must consent to the transaction, which means that an interest exchange under the default rule, keep in mind that you can opt out of the default rule pursuant to the terms of the operating agreement, but under the default rule, the interest exchange doesn't allow you to do the thing that the reverse triangular merger does in the corporate context, right? It's essentially a unanimous consent requirement. And I also want to flag that we didn't resolve the question of whether unanimous consent was the appropriate metric. We left that issue open. But the point I'm making is, to the extent unanimous consent is the default rule, you're essentially enabling in an interest exchange the same thing you could do in an interest purchase transaction, where the acquirer just simply purchase the equity interest of the target LLC's members. So again, I'm kind of puzzled about what this accomplishes, unless there's a tax angle I'm missing, right? Unless an interest exchange is taxed to the owners of the target entity in a way that's different than a stock sale would be or a reverse triangular merger would be, in which case maybe we want to preserve the interest exchange as a alternative transactional structure to allow people to have that tax flexibility. But I'm innocent of the tax rules involved here, so I have no idea.
I'm thinking it might be a B reorg, but I don't know.
Is that different than a reverse triangular merger?
Yeah, I don't know. What do you, other tax folks, what do you think? I haven't looked at reorgs for a while.
I haven't looked at 368 in a long time.
Meanwhile, back at 368.
Everybody pulls out their code.
Oh, the
I mean,
code.
if everyone followed what I just said, my point is from a business association's perspective, from an entity law perspective, again, I don't see what this accomplishes that you can't already just accomplish with the owners of the target entity just selling their ownership interest to the acquirer,
Well,
unless it's taxed differently.
so is there like, what is the consideration? I mean, interest exchange makes me think the consideration is stock, right?
It could be anything, including stock in another entity. Could be anything that's so in the language of the statute, the consideration could be interest, securities, obligations, money, or other property rights to acquire interest or securities, or any combination of the foregoing.
Isn't it a notional distribution up and over and then down? Isn't that the way that this works in LLC tax world? I'd have to dig into it. I mean,
Over
I
the
think that's,
top thing.
yeah, I think that's why it's different. I also don't
That could
understand,
be.
Mohsen, why you're so hostile to including this, even though you don't think anybody's going to use it.
It's for that reason. It's that I think that one thing that is not valued in law is simplicity and making it comprehensible to a non-expert.
So I've never done an interest exchange. I don't know which states permit them, but on the description that you just gave, Mohsen, one advantage that I see is the change of control provisions in contracts. So one of the main hurdles that we face anytime we have a transaction where we're selling a business is figuring out which contracts allow that and which contracts can hold us hostage. You know, which vendors do we have to go to? Which customers do we have to go to get consent? And a lot of those are tripped up by mergers. But
Okay,
I don't see interest exchange referenced very often. It's more of a change of control.
But the statute contemplates that, James, and it has a provision that we'll get to in the very first section if we go down this path. It says where the LLC or a member of the LLC has a contract with a counterparty, it gives that counterparty special rights arising from a merger of the LLC. Those rights also arise when the LLC engages in an interest exchange. So it doesn't give you an out. And by the way, it is a change of control still, right? If change of control is the relevant language, this is still a change of control. If merger is the relevant language that gives those rights, the statute says an interest exchange is treated as a merger for purposes of those contract rights.
Then I have the same question mark over my head that you have over yours.
Mohsen, would it be possible? I know some state law conversion statutes also have a similar 100% requirement, but their acts also allow that 100% requirement to be amended or revised through changes in the operating agreement. Basically, for example, if the operating agreement says that the company can be converted to a corporation by approval of the board or by less than unanimous consent, it's a way of essentially forcing essentially forcing everything to happen. So, is this section basically allowing more creative lawyers a way to force a transaction like this?
Yeah, so this is certainly a default rule. And by the way, it's a default rule when we talked about it in the merger context 2 times ago, right? And so the operating agreement can certainly provide for a lesser amount of consent required to cause the entity to engage in this transaction. And so, yes, it's a default rule that can be altered. However, I do think that if an operating agreement would alter this default rule with respect to interest exchanges, it seems implausible to me that it would not at the same time alter the rule with respect to mergers, in which case you could accomplish the same thing by a reverse triangular merger. But then if the point of this whole thing is to avoid the formality of having to form a wholly owned subsidiary for the acquirer, then we do have this advantage in those operating agreements that opt out of the default rule.
Okay.
I'm happy to go through it. I just wanted to tee that up so that if anyone ever asks you as a member of the work group, why is this in here? You'll be prepared to provide some answer. I don't have a great answer other than it was in the uniform statute and no one saw a reason not to do it.
Well, I think isn't the answer that it does provide greater simplicity in terms of not having to create a new entity? Yes,
but only in operating agreements that do opt out of the default rules. I think what we just got to, right? If you have an operating agreement that opts out of the default rule of unanimous consent, that means that you can engage in an interest exchange instead of a reverse triangular merger and not have to form the new entity to enter into the merger transaction.
So your point is that
under the default rule,
under the default rule, it's just, it doesn't give you any advantage over actual purchase.
From an entity perspective. Now, again, the tax perspective, I don't know. Maybe there's, through the alchemy of tax, this is treated differently than just a straight up sale of equity interest.
Well, it depends on what the consideration is.
Yeah, and I understand that. But is that true, Roberta? That if this was a sale or an exchange of equity interest for some whatever the consideration is, it would be treated differently if it was called a sale versus an interest exchange?
Well, I mean, interest exchange isn't exactly the word that the Internal Revenue Code would use. They would use, well, what was the term they use? But basically, it's qualifying consideration, right? And that generally, so if this was all in the corporate context, the acquirer could acquire control of the target using acquirer stock, and then it would be a tax-free transaction. And it doesn't, so they wouldn't have to acquire all the stock, right? Just a sufficient amount to have control.
Yeah.
Whereas if the acquirer just pays cash, that's a taxable transaction. That's not, there's no 368 reorg there. So, and the exchange does allow for cash because it's securities or any, I believe it does. Exchange.
Yeah, there's money.
Money, right. So, you know, it just depends. In other words, this doesn't impact at all taxability. The tax code deals with that. If it's cash for stock, the seller's paying taxes, capital gains. If it's exchange of stock for stock, then as long as you can fit into one of the 368 reorgs, you're not paying tax.
Then I think if the rationale we have for including this provision is that for those operating agreements that opt out of the default rule of unanimity on the target side, this saves you the step of having to form a new subsidiary and engage in a reverse triangular merger. That's a plausible rationale to include interest exchanges as a alternative transactional structure. I don't think it's a great rationale.
About 40 minutes last time.
Sorry?
I feel like we had this argument for about 40 minutes last month.
Yeah, but I didn't think about this aspect of it, which is the unanimity requirement. Now, another way to go about this is to, and we didn't decide this in full when we talked about the merger provision, which is to not use the unanimous member consent as the default rule, to require some kind of majority consent, in which case then the default rule would apply to all operating agreements that don't opt out of the default rule. Right, and then I think the argument's a little stronger, but I just want to lay that out.
I think we'll get to that part of the discussion when we get to 1033, right?
We will, although I don't think we'll break any new ground because it's the same question that was raised in the merger context.
Mohsen, isn't there another way around the unanimity rule, and it's called drag along rights? Often these entities are set up with buy-sell type of arrangements, and often they're going to have drag along rights that deals with the unanimity issue.
Right, that's just opting out of the, that's correct. In my view, that's just opting out of the default rule, not in the operating agreement, but in a separate contract between members.
Right, because it would be well, maybe it would be in an operating agreement, actually.
Oh, yeah.
But it could be like in the corporate context, it's typically a standalone agreement.
Yeah, the merger is superior to drag along because if you have a holdout who doesn't sign in breach, you still don't have a signature. Whereas if you file articles of merger, your merger is done. There may be lawsuits to come, but you've actually gotten your deal done.
Yeah,
I mean, I don't know what Mohsen does on this. I don't see the value, and in fact, the very modest value we've identified of eliminating one filing is far outweighed to me by the education that would need to occur with the bar, just to help them understand what this new, very unusual provision is.
But James, doesn't the merger also have unanimity? In fact, they all do. When we get to conversion, they have the unanimity unless you opt out. So can you complete the merger if you don't have unanimous consent, by the default rule?
Last time we had disagreement, or actually maybe it was 2 times ago, about this majority versus unanimity issue. I feel like that's going to be a consistent theme for conversion, merger, interest
is.
exchange.
It is.
And my own feeling is that however we come down on that, I think it's going to be the same for all of
I
these.
agree.
It must be.
I feel like we should make a decision about whether to do interest exchange independent of whichever way we come down on that unanimity versus majority issue is sort of my thought on it. You know,
Yeah,
it either
but
has
doesn't-
value or it doesn't, regardless of what we decide. on that
But
issue.
doesn't Cody that if we, for example, change to majority, which is what by the way ORS does, it's majority, and the uniform acts are unanimity. But if we change to majority, doesn't that make the interest exchange more palatable?
More useful, certainly. I think.
Well, what do you mean more palatable? I mean, are you?
More useful,
Are
maybe.
you saying that
More
you would have interest exchange be unanimous, but merger be majority? I assume we would have them all be
No,
majority.
that's what
and
I'm
all be
saying.
unanimous.
No, that's what I'm saying, Cody. Let's just say this group decides that we're going with the ORS approach, which is majority in all of these. Okay. My point is doesn't majority make it, as Roberta was saying, more useful in interest exchange? Kind of going down the path of what I think Cliff was talking about, in terms of if one way to move things forward over the minority is you only need majority consent. So I'm just saying that if we switch the paradigm from unanimity to majority on all of them, doesn't it make this more useful of a tool?
It does, I think, because now the default rule essentially would be that this would be a more easier, simpler transactional structure than a reverse triangular merger as a default matter, and that an operating agreement would have to opt out of the majority requirement into unanimity for this to no longer be any more easy of a transaction.
Can I ask the same question Jeff asked, but let's assume that they were both unanimous, merger and interest exchange. Does your answer change?
It does, because at that point, if unanimity is what's required for an interest exchange, if all the target owners are already willing to depart with their ownership interest, they can simply do it in a sale as opposed to an entity transaction, which is what a interest exchange is. They can just sell their interest.
Right, but if they're choosing merger versus reverse triangular, I mean, my understanding is whether we do interest exchange or not is just simply a question of, do we want to allow that as a shortcut to doing what you can otherwise do with a reverse triangular merger? Isn't that the only question?
No, because
Yes.
the issue I raised this time around is that if unanimity is the rule, then it's the exact same thing as a stock sale or an equity interest sale, an LLC interest sale, which isn't necessarily in my mind, that's a simpler transaction than drafting a plan of interest exchange, et cetera.
Right, but I guess I feel like maybe that's a comparison of not apples to apples, because if we're talking about, I thought whether to add this, because you can always sell. You don't need a merger to sell, and you don't need an interest exchange to sell. So that's option C is a sale.
So-
Options A and B are merger or interest exchange, right? And so, or at least as I'm understanding it. And so I think that the question, and I don't care whether we do interest exchange, like I don't want to teach CLEs is a valid consideration for not adopting interest
No,
exchange.
it's not.
I think so.
You know what?
I'm going to be teaching the CLEs anyhow on getting people up to speed. So I mean, I get that it's one more paragraph in your materials, but I think that needs to be off the table.
I think what we're looking at is sort of the difference between simplicity in the language of the statute and flexibility.
Yeah.
And also what I don't know, and I'm sure practitioners know, for a purchase, what do you have to do? Do you have to do a tender offer, or what's the mechanism of doing that? If you need to get all the members to buy.
Well,
How
if
do you
all the
do-
members are already on board, you
To
just
sell.
write up a contract to which you have them, you're the counterparty to the sale contract,
Yeah, everybody has to be a counterparty.
Yes,
Where-
to obtain
It
100%.
depends on what your documents
With
say.
respect to an interest exchange, though, it would only be the LLC that would be the counterparty, but all the members would have to vote to say, yes, that's fine, but they wouldn't be counterparties.
That's true.
So does that make it simpler?
I don't think so in practice. I think I sort of regret raising the issue because I think most people don't care and are just happy to go with it. Maybe it's just the academic
I
in me
just
that
feel,
wants some
Wilson,
kind
like
of
we've
logic or
had this
consistency.
argument already, and I don't know why we're having it again.
It's because the default rule is unanimity is why raise it again.
Right, but we could have
no one
talked about
cares,
that when we
let's
talk about
proceed.
1033, right? I mean, okay, let's.
Right. It's just that we haven't
Okay.
decided whether
Okay,
we're
why
gonna.
don't we take a poll, and the people who would like to continue on with 1031, who would like to continue on talking about 1031?
But wait, can I be clear? Are we talking about whether we're going to include it in our version of ROLCA or not? Is that what the question is?
Is it the question whether we're going to have interest exchange at all?
Right.
Yes,
That's what I'm
Mosen has
asking.
been trying to persuade us for the last 3 months that we don't want this section in our revised Uniform LLC Act. And I'm not convinced. So I would like to keep it, but other people may feel more like Mosen has felt and feels. So, you know, if you would like to incorporate interest exchanges into this, raise your hand.
I want to keep 1031 in all its iterations, including in the federal tax code.
This
If
question
you
was-
like-
I would
if
say
you
I would say that was
Oregon LLC Act.
Okay, so no, so
That was
if
inconclusive.
if you feel strongly, as Mosen does, that you would like to skip directly to conversions, 1041, raise your hand. Okay, so let's put a pin in this. Mosen, are you prepared to talk about section 1031?
Let's go ahead. Okay, so now that I've described basically the transaction that we're describing here, let me start with a couple of preliminary points of discussion. One of which is that, as we talked about in the context of the merger provisions of the RULLCA, everything is subject to our going through the definition section, part 1 of Article 10, and agreeing to the terms there. So I don't want anything that might show up in part 1 to present an issue here where we've kind of tabled that discussion for a later point in time. The other preliminary point I want to make is that the interest exchange provisions here have 2 possible reference points or frames of reference that we might consider. One is the stock exchange or share exchange provisions that already exist in the ORS corporations chapter. Corporations, as we learned last time, or as I learned last time, do allow for share exchanges already. And so we can look to that as kind of a model of what existing Oregon policy is. The other more important frame of reference, I think, however, is the merger provisions that we looked at 2 times ago. I think it's more important that the share exchange provisions for LLCs in the statute mirror the merger provisions for LLCs in the statute than mirror the share exchange provisions in the ORS.
Right, and James just dropped into the chat the majority vote provision. Thank you, James.
Oh, existing ORS, yes, that's right. ROCLA, we had this discussion 2 times ago, has this unanimity requirement, and so there's what I have in my notes is an open question of whether we want unanimity or majority, and so we just haven't resolved that. But as been previewed, the same issue is going to come up time and time again in all of these transactions, and so this is something we will need to decide, and it does have some relevance here. Okay, so with that, again, my thinking is it's more important that these interest exchange provisions mirror, conform to what we already discussed with respect to the merger provisions of the RULLCA than mirror or conform to what we have in the share exchange provisions of the ORS in the corporation chapter.
They all need to. Mosen, can I make a comment here? Just going back, I hate to do this 1031, but I think I may have found a reason, unless I'm misunderstanding this, why this is important to have it. We've talked about the merger is one way to deal with it, but this is involving a domestic LLC exchanging for a domestic or foreign entity, so different types of entities. So you can't merge a corporation and an LLC together. So, you know, the merger, if it's 2 LLCs, that's another option. But if they are 2 different types of entities that you can't merge together, doesn't this give us flexibility to do something that otherwise we can't do through a merger?
My understanding, and this is 1021, is that you can certainly merge a LLC with a different entity type. 1021A1 says that one or more domestic LLCs may merge with one or more domestic or foreign entities.
I guess probably what's driving my point is really, I see what you're saying, is that you'd never want to do that from a tax perspective for the most part. But okay, all right.
And I guess I would follow on with that current ORS 63481 dealing with merger allows cross-species mergers. So you can, and in that context, I think more and more we're seeing LLCs that are taxed as a corporation. We're seeing that hybrid entity more and more. So, what state law, we may be merging an LLC into a corporation, but tax law, they could both be corporations. So
good point, Michael.
I think, we kind of have to have glasses that look both ways in terms of state law and tax law.
And even if the LLC was not a corporation under tax law, it would not be a problem to merge the LLC into a corporation. What would be a problem would be the other way around.
Yeah. You may have an inadvertent liquidation. Exactly.
Okay. So Jeff, I think your question was answered then.
Yes. Okay, sorry.
Great.
Yes.
So 1031 essentially mirrors and doesn't accomplish anything. It's very close to 1021 that we discussed already in the context of LLC mergers. The only provision that I would point your attention to is subsection C of 1031. Subsection C includes a provision that was not in the analog merger provisions that we already discussed. And it's the provision that I referred to in answering one of James's questions, which is it provides essentially that if there is an agreement that either the LLC or one of its members has with a third party that gives that third party special rights arising out of a merger of the LLC, then those same special rights will arise if the LLC engages in an interest exchange. The reason for this rule, this provision, is that interest exchanges are a relatively new and novel transactional structure. And so parties may have negotiated agreements that gave a party a special right arising from a merger of the LLC and did not know to include interest exchanges in that contractual language. And so this essentially says you're still covered. A interest exchange is equivalent to a merger with respect to whatever special rights you had arising from the transaction. It's teed off this concept of a protected agreement as defined in Part 1 of Article 10. The protective agreement is defined quite broadly, essentially to mean any agreement that the LLC or any of its members or managers are a party to. The one other thing I'd point out about this rule, which Volcker calls comments call a transitional rule, is it only applies to agreements that were or contracts that were made prior to the adoption of Volcker or of this act, and that haven't been amended since the adoption of this act. The idea is if the parties took the time to amend the agreement after the act was adopted, they've been put on notice that interest exchange are a potential transaction type and that the counterparty should negotiate protection for themselves at that point.
There is, just so you know, if you haven't seen it yet, in the conversion and domestication, there is this provision. It's the only place it's not is in the merger one because, mergers in all the contracts.
Right. I have no objection to this provision. I think the language is a little funny, but I'm not inclined to change it just because of my idiosyncratic beliefs.
You know what I think is really weird about this language is it doesn't talk about until the agreement is amended after this date. It talks about until the provision is amended after this date. And to me, that sounds like a recipe for mischief because, nobody specifically goes and amends these provisions very often. And I can imagine an agreement, an agreement with a supplier, an agreement with a lender, where you had this kind of provision that talked about, a merger would be an event of default, and then you do an extension agreement or a pricing change or something, and you don't think to amend this, and then this happens, and then there's a question of whether this is effective, and it just seems weird to me to talk about the provision rather than the agreement containing the provision.
It kind of makes sense to me, though. I would argue to the contrary. you have to amend the provisions. So if you enter after the effective date of the act an amendment to the agreement, but you don't touch the provision, this subsection C still applies. If you amend after the effective date of act this actual provision and you don't add in interest exchange and domestication and conversion, that shows an intent that you did not want to cover that. So I think the fact that it talks about amending the provision as opposed to amending the agreement actually matters a lot, because if you amend the agreement and don't touch the provision, this still controls. If you amend the provision itself, then this doesn't control anymore because it shows intent. You didn't want to include an interest exchange in that provision.
I agree
but I
with
almost
Jeff.
feel like it should be the other way around. I mean, if you're going to amend your agreement and not change this provision after the law changed, then that ought to be an indication that you didn't mean to change this provision. I mean, I guess you have to draw a default rule one way or another. I just thought it was weird the way they drew it. I guess Jeff thinks it would be weird to draw it the other way. So,
well, because my concern about the other way is they may not have even thought about this provision when they amended the agreement, and thus your new rule would take place, and if I understand correctly, in subsection C wouldn't apply anymore, and yet there was no thought given to it. So I think that I like the way it is now because it requires thought about this provision and the decision to amend this provision and exclude, if by no other reasons, by lack of reference, interest exchanges and the other ones as well, domestication and conversion.
yeah, but at some point in time, if you have an agreement and you've just done amendments to it for the last 25 years, and you haven't amended and restated the agreement. I've seen contracts like this. I've seen loan agreements like this, where the loan was made 20 years ago and they just do an annual amendment to change the pricing. I mean, at some point, when do you lose this presumption that you didn't mean to change it? I can see this for a year or two, or maybe even 5 years, but at some point, you got to get with the program. And if it's meant to be a transitional rule, it seems to me it would make more sense the other way. I don't feel strongly about this. I mean, if people want to keep it the way it is, I just thought it was weird.
Well, I mean, I do think if you look at the comment, it's intended to be a transitional rule. And, we haven't talked really about timing on effective dates of this either. So that might be a question, Sandy, to raise with Sean, that what his thoughts are with respect to things that are intended to be transitional rules within the structure of the document.
Yeah, I think you're onto something, Valerie. I think there's going to be a need for consistency in that language throughout the statute. Yeah. So I'll definitely flag it.
Okay.
And I think Teresa, you're right. And I think that's sort of a general rule of contract construction, right? That if you amend and you don't change it, it's supposed to stay the same if you don't change the particular provision. But I think Jeff also makes a point that it might help the unwary, but on the other hand, it might hurt the unwary. So I think Valerie, you're pinning this.
I am.
Okay.
Yeah. I mean, I think there's logic to this rule because these things, interest exchange, conversion, a little bit less, domestication, most states up until recently don't have these things. We didn't even talk about them. I mean, conversion has been around a while in Oregon, but up until the point when we adopted it, it really didn't exist pretty much anywhere. I think we were one of the early adopters of it. So I think it makes sense because there's like going back to, and I have a loan, Teresa, exactly what you're talking about, a credit facility that was done back about 25 years ago. We're on the third amended restated version and in about the 8th amendment of the third amended restated version. But that's the situation where, some contracts have been around a long time and they just refer to merger. And I see a lot of logic to broadening that to all these other tools. And if you want to change the vote rights, if you will, with respect to a conversion as compared to a merger, go touch that provision and change it. Otherwise, I see the logic in this provision. It's otherwise, there are all of these arrangements out there when this is adopted that can't utilize this without going in and actually changing those arrangements to provide for domestication and interest exchange and stuff. So,
and in asking for that, the party might have to give something up, right? They're not going to the LLC or its members are going to just give that away And so now they're going to have to give something up to get what they already had before the statute was changed on them.
You mean like the minority interest holders have leverage to negotiate with the majority, or
Well,
amendment to the contract, the operating agreement?
I think it's basically the same thing you're saying, Jeff, which is it changes the fundamental understanding that parties had before we changed the law on them. If we don't have this provision in there.
Oh, I'm going to put a note, and Sandy will confirm that we need to check with Sean Brennan on this.
On the effective date question only.
Well, I think if we're going to have this provision, it ought to have some kind of a time limit. Like at some point, people
Right.
need to either change it. And you can't rely on the default rule for the next 25 years.
And that's the piece I think is going to need to be consistent throughout the statute. So I think that's why it's one of these across the board decisions they're going to have to make.
Absolutely. This language is identical for the most part in the other sub chapters. So yeah, I think a lot of, and it's been said, I think we need to be consistent in all these things. And this reads a lot like conversion when we get to it, which Michael and I are doing. And same with the merger and domestication. They read very similarly.
I'm not sure how much you guys are going to have to talk about after all this.
I got prepared for the granular, but I'm beginning to believe that I should back away from that.
Well, and my philosophy is we went through the merger provisions, and I'm only going to highlight where these are different than the merger provisions rather than reopen discussions we've already had. Okay, my takeaway here is that we're fine with this, although we need to further think about what that effective date and whether there's going to be essentially end date, drop dead date at which agreements need to be amended, or else they don't get the benefit of this transitional rule.
Right.
And that question is going to be tabled until we talk about the other transaction structures.
Yeah.
And so we're keeping the word provision near the end there.
Okay.
Yeah, I think where we ended up, just to be clear, is a drop dead date on this maybe, but otherwise accept it.
Right.
Okay.
That's the note I've got.
Right. Okay.
This is going to come in as 63A, so I don't know what the plan is to go from 63 by itself to 63A. So.
Okay, so I'm ready to move on to 1032, unless anyone wants to discuss this further. Okay, so 1032 again is very close in its language to what we already discussed in the merger context in 1022. Essentially, all this does is require the acquired entity to adopt a plan of interest exchange, very similar to the plan of merger that we discussed last time. One thing that I'll note, so in that respect, it's very similar to what we've already talked about with respect to the merger provisions of the RULLCA. So I don't think there's a whole lot to necessarily consider there. So the one point I'll make here is looking at the ORS corporate provisions relating to a share exchange. Those provisions, as far as I can tell, do not expressly contemplate that a plan of share exchange could include amendments to the target corporation's articles of incorporation. However, here, consistent with what RULLCA provides in the merger context, a plan of interest exchange could include provisions that amend either the certificate of organization for the target LLC or the operating agreement of the target LLC. I see no reason to alter this. Like I said, I think it's more important for these provisions to be consistent with the merger provisions that we've already talked about than to be consistent with the share exchange provisions of ORS. But I just wanted to note that.
Thank you.
Just to confirm, as my note wasn't clear on this from the merger talk, ORS talked about how you have to have in your plan of merger talking about the basis. We decided we're just going to use the role language that doesn't say basis. Is that right?
That was my recollection, yeah.
Okay, thanks.
And the same would apply here. Is there anything in this one that anyone wants to talk about beyond what I've just highlighted? Okay, great. Like I said, I think this will be easy now that we decide to go with it, because it's all very similar to mergers, the merger provisions that we've already talked about. So that brings me to 1033. which describes the process by which a interest exchange must be approved. And again, the provisions here are very similar to 1023 in the merger context that we've already discussed. The things I would point out here are, again, under 1033A1, what's required is the default rule is that all members of the target entity must approve the interest exchange. So there's a unanimity requirement. That is the same language that we saw in the merger provisions of ROLCA, although we tabled that discussion of whether unanimity is the correct rule. I'll just point out that in the context of share exchanges under the ORS provisions dealing with corporations, unanimity of shareholders is not required. What's required is an absolute majority. A majority of all outstanding shares must vote in favor of the share exchange. And so to the extent we stuck with unanimity here, that would be inconsistent with the share exchange provisions of the ORS. Did everyone follow that?
Yeah, does anybody feel strongly one way or the other about this?
Well, again,
the unanimity thing?
Well,
that's the same issue.
I think that's a hotly debated topic. I didn't mean to open it now. I just wanted to flag that now, and I think we need to have a more global discussion after we go through conversion and is it domestication, Jeff? The other one,
because I think it's the same standard throughout, right?
That's correct, and so I think it makes sense to have this hot debate after we've gone through all the
I
transactions.
do love how excited you got about that hot debate issue.
Well, I think it took up most of our time when we talked about mergers.
Although I think it would be helpful to have that discussion sooner than later, because once we know what that standard is, I think it helps us evaluate the provisions we're going through.
That's a fair point, Michael. And I'm happy to have that discussion now because I think we've kind of seen what's already come and we have a sense of what's coming. And I do think it does help to know what the standard will be in assessing each of these provisions on its own merits. So well, I'm happy to open that discussion now or wait until we've looked at the other.
Okay. Well, and we only have conversion discussion now.
We only have conversion left, and it's the same issue there. So we're, again.
I do not want to have this fight again when we get to conversion.
No, and I just have this recollection, and it could be a faulty recollection, that there were some provisions where we thought unanimity was important, and I don't remember what those were.
Right, but
I'm sure we'll talk about them later.
As between merger, interest exchange, and conversion, I do feel that it should be the same standard. Do we want to talk about this now? Because if so, I'd suggest we take our coffee break a little, or refill our coffee cup break a little bit early.
Could use that. I think we should, because it's an important issue that we need to discuss and resolve. And to be clear, the way I would approach the majority, if we went that way, majority unless the operating agreement otherwise provides.
Of course.
So you can always build in the unanimity or the 80% supermajority or whatever. I don't like the unanimity because it really doesn't have the.
The debate is whether to have the debate.
Do we want to talk about this now, and do we want to take a coffee break now?
I would love to get
I'm not caffeinated enough for this discussion at this point.
Let's get a coffee break.
Coffee.
Okay, let's take a coffee break. We'll come back at in about, let's say about 10:30.
Okay.
So the unanimity requirement that we saw in the merger provisions also applies here. Note here, however, it only applies to the acquired entity. What's required is that the members of the acquired entity unanimously consent to the plan of interest exchange. But that's consistent with what would have happened if the transaction had been structured as a reverse triangular merger. The owners of the acquiring entity wouldn't necessarily have any say in the transaction. It's only the owners of the acquired or target entity that would have a say in the transaction. So that's consistent with the merger provisions in that regard. I'll make the case. So I hear the reasons for. First of all, let me observe that this is simply a default rule. So the stakes here are lower than we might think.
Right.
The parties to the operating agreement can opt out of the default rule. So this is not a rule that we're imposing on anyone. It's just a default rule when the parties fail to address it. So the stakes here are not that high. Secondly, I think the unanimity requirement makes sense in all these scenarios because these transactions allow parties to accomplish things that they otherwise would not be allowed to accomplish under the other provisions of the statute if we went to a majority model. For example, under 407, there are certain things that the LLC cannot do outside the ordinary course of business or amend the operating agreement without the consent of all members. Well, if we went to a majority requirement here, a majority of the members could somehow get around that provision by engaging in some kind of transaction that is structured as a merger, but it has the effect of essentially having the business do something out of the ordinary course because there was someone who was obstinately refusing to agree to that. Likewise, with respect to dissolution, dissolution requires the unanimous consent of all members. It wouldn't make sense to have a majority requirement for a merger or other type of transaction that could have a similar effect as a dissolution would have. So I would, for purposes of consistency and to avoid kind of opportunities to game the statute, I would say we should just keep the unanimous requirement here, recognizing again that it's simply a default rule.
I agree, actually. Any debate?
I'm in agreement.
Well, I just would say on the reverse side, if you go with the merger, you know, excuse me, if you go with the majority, then, you know, there was, at least in the corporate context, and I'm trying to think of in the LLC context, you had minority rights. So if the majority decided to push through a merger and on the corporate side, under our current corporate act, then the minorities at least have those minority rights, which is getting them bought out at fair market value, what have you. If we had similar rights in the LLC, would that change things for people?
I left that out. That's the most important part. There is no statutory appraisal rights under RULLCA like there is under the corporate statute, right? Under the corporate statute, people can get comfortable with majority vote because the minority still have a right to statutory appraisal for their shares if the transaction proceeds. Minority members in a majority scenario here would not have statutory appraisal rights. The party's operating agreement would have to affirmatively provide that. And
But
since we don't have that,
do we not have common law rights? And I'm looking to the litigators in the room here. Don't we have, doesn't LLC members, minority members still have similar common law rights under Oregon law?
I don't know. I don't know. I never litigated that. I would be somewhat surprised. Not that I couldn't be surprised, but I'd be somewhat surprised given the sort of pervasive regulation of the statute here to then say, well, you know, there's this, you know, corporate statute that pre-existed the LLC statute. They had all this stuff in it. And then the legislature went and enacted an LLC statute. And then especially if we're doing it now, after we've had this discussion and don't write it in, I think it'd be unlikely, I'd say, that a court's going to infer that there was a decision to maintain or you know, or anything like that, any common law rights that exist.
Well,
there's certainly fiduciary duties that still apply here. And so to the extent a controlling member or controlling group are exercising the control in a manner that benefits themselves at the expense of the minority, there might be a common law fiduciary duty of loyalty claim that the minority can bring against the controller. So but that's the only level of protection that we have if we go to a majority scenario.
And that's different from the common law right Jeff was proposing or discussing. And also, I'll just note, fiduciary duty scope, you know, was hotly contested before and we've punted. So, you know, it's somewhat hard to say, well, you've got the fiduciary duty claim when we don't know if there will be that claim as yet in our overall discussions.
Well, and I think that based on what was just said there, that I think the reason in part that this says unanimous is because there are no statutory minority rights. And if we flip to majority, we might need to consider adding in statutory minority rights to deal with this very issue. So, and it did dawn on me in the break that if we do flip this, we have to look holistically at this legislation because, you know, the domino effect, you change in one place, something as significant as this, you have to start looking at what you have to change elsewhere to be consistent. And one thing I'm seeing here is you would probably have to build in minority rights if you go to majority interests, which don't exist. So that's an example of a domino effect.
Do they exist under current ORS 63? in these
No.
areas?
Well, they exist in the form of statutory appraisal rights for sure.
Yeah, okay, that's right.
Is that in the LLC Act though?
The existing LLC Act.
Correct. That's my question.
Let me look. I'm not.
I
I don't know.
didn't think so.
Current Oregon law is majority vote and no dissenters or appraisal
Yeah.
rights.
That's
Yeah,
what I thought.
the corporate act's got the dissenter and appraisal rights. It's not in the LLC Act.
I guess making the argument from the other perspective, and we've talked about a number of situations where our Oregon legislature has made a decision in terms of policy, and I read our current ORS is really evident of that policy that the Oregon legislature has made in terms of these kinds of transactions. The default rule is majority, and people certainly have the ability to alter that default rule in their operating agreement. So I think if we're going to go with unanimity, I think we have to have the ability to explain to the legislature, well, we think, current law is deficient or incorrect, and here's why. I mean, this is a big policy decision that we're superseding current law. And I guess I'm not hearing a strong argument that current law is deficient such that we need to correct it. And is that above our pay grade?
Well, one deficiency
Jeff,
though is
Teresa,
current law
Julie.
doesn't have minority rights.
Okay, Teresa?
So it seems to me that anybody that's represented by a smart lawyer under the current Oregon law or under the proposed ROLCA provision can make it be whatever they want to. Because whether you start with the default rule of majority and you make it unanimous, or you start with the default rule of unanimous and you make it majority, it's going to allow everybody on this call that forms LLCs to have the flexibility to do whatever it is their members want. So the real question here in my mind is, what should be the rule for the carpet layers, the people who aren't talking to somebody on this call? And I guess the question is, if you asked two average people who are laying carpet whether they thought they'd have to agree before they could do something really significant with their company, like merge it, or they're never going to think of an interest exchange, it's never going to occur to them, but do something significant with their company, period. I mean, that's probably as far as they're thinking. Then the question is, would they think they had to agree on that? And I would think most of the time people would think they would have to agree on that, and that the appropriate default rule should therefore be unanimity. And I like the way that ROLCA does that, because it doesn't stop anybody from doing something different, but it protects what I think the reasonable expectations of the ignorant are.
And I thought that our marching orders were more or less, we'll go with ROLCA unless there is a significant reason why we won't. And so I guess that raises the question of, well, what was the significant, is this a significant thing in the Oregon statute that we want to keep for a particular reason? If not, we want to go with ROLCA, just sort of as a general principle. Am I correct in that assumption?
Yeah, I think you are, except to the extent that we have, a clear, relatively recent guidance on why, on a policy statement. For example, all the stuff with respect to transparency, we've been very good about trying to include more of the transparency language.
And
go ahead, Cliff.
Yeah, I mean, I generally speaking, I hate unanimity for things, but here I do think it's warranted and the right decision. I can see a lot of gaming happening if it is not required unanimous. And frankly, if it's not unanimous, then people could essentially incorporate transactions like this, even if they're not in the minority of ownership, if it wouldn't be addressed in the operating agreement. For example, well, a majority of members is, if there's 3 members, it's 2 out of 3. And even if those 2 members each have 5% and one has 90%, they could control and affect a transaction like this unless the operating agreement prevented them from doing it. by requiring unanimous consent.
Right, and just
Or-
looking at the sort of legislative history on 63-487, or at least the the amendment history on the bottom of the bill. It looks like it was incorporated into the initial bill, and then when they did the first round of revisions in '99, it was brought in. So it hasn't really been significantly addressed in the last several years. And I agree with what Cliff is saying.
I'll speak. I could be the lone voice or the lone
Knock yourself out.
fervent voice in the other direction. I think
Alone.
a few different. Okay, thanks, Jeff.
I'm with you. I'm with you, James. I'm surprised on Cliff's position. Come on.
A few points in Teresa's example with our 2 carpet layers. They're both going to have to agree whichever rule we adopt. You don't get a majority without both of them. What I'm concerned about is the 2% owner or the 9% owner or even the 25% owner who ends up being a holdout. That is a real thing that happens.
Yeah.
And while the LLCs that we form can be proactively designed to get around this, I would say in my practice, a majority of the businesses I sell are formed either by the client themselves or by LegalZoom. It's people who started something up. They didn't have much money. They're surprised today that there's a buyer offering tens of millions of dollars for their business. And I very much worry about having that much money on the table in a sale transaction. And now my 4% owner wants disproportionate consideration or wants some kind of ransom to get the deal through. So I think that's a real concern. And this would be a change from current Oregon law. So I think we would have to be able to explain that.
I have feelings that, or rationales that cut both ways on this issue. On the one hand, I agree our sort of starting premise is to adopt ROLCA and depart from that when there's a strong policy rationale for not doing so. And sometimes that's because the Oregon legislature has recently, and sometimes because Oregon legislature, even not recently, even as far back as '93, made a different choice. And here the legislature said majority. On the other hand, I also think that, if we depart from the current ORS here and go with unanimity, which is my own, personal thought, I think that's in the best interest of the carpet layers on the whole. I also think, though, that if we go with majority here, we need to also then, consistent with that, stick with the Oregon legislature's 1990s decision to not allow a lot of opt-out in the operating agreement from the fiduciary duties. Because when we talked about fiduciary duties earlier and how the operating agreement can eliminate or reduce them, we had a lot of debate about that. And I think if we're going to allow people to water down and weaken their fiduciary duties, which I will advocate against regardless of whether we allow mergers by unanimous consent or not, but especially if we're going to allow mergers to be by unanimous or by majority consent, which is what the current ORS allows, we need to, I think, have robust fiduciary duty protections as the current ORS has. So I just want to put a pin in that, just sort of, I'm okay to go with majority or with the current ORS majority language if we stay with the current robust fiduciary duty that's in Oregon law, but I don't want to go with the majority language here and then water down the fiduciary duties at the other end.
I think it's a different argument, but I don't necessarily want to get into the fiduciary issue there, but also if we were to go with majority, I would still advocate that we need more of a majority of economic interest or capital accounts or something else. And I know we discussed this early on, and we just kind of came to the conclusion that it would be too difficult, and it diverges from any other state's approach to it.
I can't remember right now, is majority defined by the number of members?
So literally, yeah. I mean, if there is free if I could transfer interest under the agreement and I hold 1%, all of a sudden I transfer, my interest to 10 of my friends, and all of a sudden I've got majority, even though I only have 1%. That does not seem like the right outcome to me.
So I think we've got two concerns. One is, the surprise of the carpet layers or whatever, the 3 carpet layers, 2 of which decide to sell. And And then there was the concern about the third carpet layer holding the other two hostage for ransom. And I think fiduciary duties, I think Cody makes a really great point about that. But I also wonder, why does the corporate statute say that there are statutory appraisal rights, whereas the LLC statute doesn't? Have there been any issues? I mean, under Oregon law, under current Oregon law, about, majority owners of LLCs screwing over the minority owners?
That would be like oppression claims, or?
I don't know.
There
I don't know
are
what they do.
claims of squeeze outs, oppression, things like that. There's a lot of case law about that.
They're based on fiduciary duty, aren't they?
They are. Yeah, exactly. And so, that is the protection. We don't have the dissenters' rights, like in the corporate context for LLC members, but we do have the robust fiduciary duty rules which protect the minority in Oregon in our current law. And so, I actually think it's sufficient protection. It's sort of a post hoc protection, as James was saying. I want to get this deal done. Litigation may ensue. And so, yeah, it is a post hoc protection. And it, maybe it's more protective to be unanimous, but I can also see how there's some potential cases where that 4% holdout wanting a ransom or something that could not be good. To me, it's really, I guess I care less. I still would prefer unanimity on this, but I care less about whether it's unanimous or majority. That I just want it to be clear that if we're going majority, we need to have the robust fiduciary duty protections.
But Roberta asked the question, and I don't know the answer. I wonder if anybody does. I mean, there's a difference. I mean, the minority rights in the statute are appraisal rights. And what you're talking about, Cody, is breach of fiduciary duty and damages. So I don't know the answer. Why does our current LLC Act, and more importantly, why does ROLCA not have these appraisal rights?
Yeah, so the answer to that question, Jeff, and sorry, I had to switch microphones. So sorry if I'm not coming through clearly. The answer to that question is in the commentary of 1006, which deals with appraisal rights. And what the commentary says is we don't see a need for appraisal rights when the default rule is unanimous consent.
Well, at least we're in the right place, right?
To the other, and that's a point that has been made now, right? That we can't have anything less. And so that makes our ORS LLC statute kind of bizarre because it doesn't have unanimous consent, it doesn't have appraisal rights. But those two, right, the rationale for appraisal rights is it protects the minority who did not consent.
Right. So those need to be linked.
I think it's a better tool, frankly, than the fiduciary duty because it cuts out a lot of the stuff that you have to litigate over and focuses on what's important.
Yeah,
I think Cody helpfully said the trade-off here is, do we want more robust fiduciary duty, unwaivable fiduciary duty protection, or do we want to have transactional ease with respect to what kind of consent is required at the front end? And from my perspective, I'd rather have a unanimous default rule that contract drafters can opt out of and then have more control over what can be litigated ex post in a fiduciary duty context.
Well, I mean, I just add, if you go majority and you add the appraisal rights, it's a different result. The transaction happens and what the minority gets is assurance that they're getting a fair deal. But they're forced to sell, but they're getting a fair deal on that. That's what give them. And then it eliminates litigation, right? At that point, there's no breach of fiduciary duty and litigation after the transaction's over.
You might litigate over the appraisal, but.
Yeah, but that's a simple piece of litigation. That's the $50,000 litigation, not the $350,000 litigation.
Yeah, that's the battle of the experts.
Yes, exactly. That's simple. It's just a thought. I mean, but I think what is now abundantly clear from what Mohsen just pointed out is that if we go to majority, we need to add in appraisal rights.
I totally agree with that. And I'm sorry, I'm going to have to go. So peace out.
Roberta,
and I agree with Jeff.
Arguably, that would be a bigger policy change to add appraisal rights where none currently exists than the one we're talking about now, which is to go from a default rule of majority to a default rule of unanimity. So Michael, I take your point as a good one, but right, we just identified a bigger policy change would need to be made.
Mosen, just for the record, the comment that you referenced, it's under what section? Because I think that's important to this discussion.
It's comment 1006, so 1006. On my printouts on page 193, first paragraph.
Okay.
Are we aware of any other states who have offered appraisal rights to members for LLCs?
I know Delaware doesn't. I think Washington may have. I think I can look.
That would be a pretty significant change because it seems like appraisal rights are, you associate those with corporations and not with LLCs. And so my comment, I'm really conflicted on whether to, require unanimity or to require a majority. But I'm in James' camp where you don't want a 4%er holding out on a deal that makes a sense for the 96%ers.
Yeah.
And Dave, to your point, 2515, 425 through 480 of Washington's LLC Act does include it. So I was.
Did they go, Cliff, did they go to majority then on these domestication and conversions? Did they, I would assume they did because they have appraisal rights.
Oh, wow. Okay.
2515, 400 says.
By the way, as he's looking at it, if we go majority, we now have
by the
appraisal
members.
rights. We
By members contributing more than 50% of the agreed value. So to my earlier point, it's not a majority of the members. They actually looked at kind of who's contributed the most. They looked at economics opposed to number of members.
Yeah, and I think economics is more important than a simple majority. If we go to majority, again, what under our current LLC Act, if you don't deal with it in the operating agreement, then the 80% person has one vote and the 20% has one vote.
And I think that's a defect of the current statute that maybe wasn't thought through entirely when they adopted it, that they didn't think it would be as easy as I think what Cliff described as if you have one vote and you want to outvote it, transfer fractional interest to 10 of your friends, and then you have the numbers to outvote it. And so that's why I like the idea of having the default be unanimity and then let people define for themselves in their operating agreement what will be the majority. Is it economic? Is it number of people? Are there limitations on transfers of interests to prevent such gaming? I mean, it will allow people to do their own thing in their own operating agreement, and yet it will prevent that kind of gaming by the carpet layers when 3 or 4 of them decide to get together and form their carpet laying company.
But here's an interesting result with that, though. So you can opt out by changing it in the operating agreement. So say it's unanimity and there's no appraisal rights. And then some smart attorney puts in the agreement majority. So now you've got majority and you still have no appraisal rights. Yep. So the benefit of putting the appraisal rights in is that they're there and they're always protecting the minority at that level, whether it's unanimity or you change the default rule to majority. If you do that, you don't put in the appraisal rights, the minority is then and has nothing.
So Mosen thinks that we can take a vote on this now. Are other people feeling sort of similarly on how you feel about, do we change this to we leave it at unanimity, or do we change it to majority? And then I think the question after that is then, do we need to add in all these other things that we've talked about needing to add in? Okay, so those in favor of leaving it at unanimous? 1, 2, 3, 4, 5, 6, 7. Okay. Those in favor of making it majority? 1, 2, 3, 4. Okay, so we're at unanimous.
Most of the transactional guys.
Can I also throw out, to the extent I lose that vote, that's fine. That's why we have a big group and lots of smart people weighing in. But I would invite you to think through how the change happens for existing LLCs. Does it affect them? Does it only affect new LLCs? That's a whole other thing to think through.
That's a good point.
I thought the rule in this was that this affected LLCs formed under this act going forward. As a general.
last article deals with that, the transition effectiveness.
Yeah, I thought that was in section 11.
We talked about.
I think if I remember correctly, what it says is that it will apply to all LLCs at a certain point. And James has a good point that maybe this is a scenario where, given the change in default rule, we need to preserve the default rule for pre-existing LLCs.
Yep.
That would be reasonable to me to do that.
I hear that. I think if you do that, you need some sort of a transitional period where once you're by that, you're under the new statute regardless, because you don't want to go 10 years down the road and have older LLCs, running for, with a different statute.
Well, and you also, you don't want to have the situation we had with the IC discs, where you had IC discs formed under one set of rules that people were selling an empty shell of an LLC for thousands of dollars, because it had these particular sets of rules that applied to it as opposed to new IC discs.
Yeah. I think there's some precedent that we could look at. It's a number of years ago now, but there was a transitional phase when the last iteration of the Uniform Partnership Act came in. Whereas if you were a new partnership formed after the effective date of the act, you were in the new act. And I think it was a year or two transition that if you were a pre-existing partnership, you had a year or two to make your transition. And after that, you were in the new act as well. So I think that's, particularly with some of these issues, and it may necessitate a conversation with legislative council.
Yeah.
How we do that, because it's just, we could really end up with some terrible unexpected results if we spring this on people, particularly before the bar has an opportunity to gear up on the new act.
Yeah, but if we're looking at implementing in 2020 with the 2023 session, right? So it would be effective 90 days sine die, which would put us in September typically. And you make it effective for January 1, 2024 entities, and then you give them another 2 years to educate and update. And so then we're looking at 2026 effective date for everybody has to follow the same rules. I mean, that makes sense to me, because we're talking 5 years out from now.
That makes sense to me as well.
Well,
Yeah.
So the only pre-existing LLCs that will be affected by this rule change are ones that are existing now or before the effective date of this act, and in their operating agreement fail to specify otherwise, right? And so then I come back to the question: are we really upsetting existing expectations by changing the default rule? Because by not having addressed the matter in their operating agreement, I question whether they have expectations.
Well, but they may have addressed. Go ahead, Michael.
Jeff.
Well, I was just going to say, remember, there's in all of the other than merger, there's provisions that say, we just talked about it, that if it says merger, it's deemed to be conversion and interest exchange and domestication. So a lot of agreements do deal with the merger question.
Yeah.
And that clause will apply to these questions for these other types of transactions by virtue of what the statute says, that subsection C, that it's in all of them. Anyway, go ahead, Michael.
I think the scenario that James laid out, where you have people that either have no operating agreement or one that's so vague it just simply doesn't address any of these issues, that's the default rules that were the situation where these default rules really apply. So I think that's the context that I would recommend that we have some commentary here that are, the committee was divided in a very civil conversation. I think we need to tee this issue up for the legislature, because at the end of the day, we're not the decision makers. And I certainly respect everyone in the group and their opinions, but I think some commentary so we can capture the essence of this discussion is important.
Yeah, I would defer, I think, to Susan on that, Michael. I understand that, you know, people want to be heard, and certainly this discussion that we're having is part of the public record already. And so to the extent that people are interested in that part of it, I think that it needs to be, that is available. But I do think the commentary needs to focus on the things that we agree on, not on that we were divided and you should just do whatever you want, which is my concern with this.
But I think in the context where we're making a change from current law, I think it's important to explain that and explain why we're making the change.
Susan?
I think they want, I think the conversation, and I've been in and out and I apologize for that, but I think the conversation is around whether or not you make a change to existing law or accept a different default. And I think it is important to make a recommendation and explain why that change is being made. If it's different from existing law, and especially if it's different from the existing law that the legislature has adopted more recently, even if it has been the last time they touched this code. So I do think that's important, but I think it's better to just say, this is the recommendation and here was the discussion, a comment that these are the potential issues at hand. Is
Yeah,
that
I don't think we need to write a treatise. I think something short.
No, don't. I think they don't want that, but they do want that. They want an explanation that you decided to stick with existing law and policy choices that have been made by the legislature. If you're changing, then an explanation is you chose to stick with existing Oregon law, or you chose to change it for this reason. And it doesn't need to be a treatise. It needs to be a few sentences.
What would be our explanation to going to unanimity?
You guys are the experts, not me.
No, I'm not asking you, Susan. You made the point that we should explain that, and I agree.
Yeah.
What is our explanation? Because there's arguments both ways. I mean, we just sort of vote it and majority controls, but what would be our explanation for that? And it needs to be a good one because we're doing a policy change.
Right.
Yeah, I think we've covered a couple.
You've done a number of things of this. You've made decisions of this sort all along the way. So I don't think it's hugely different. You've had a couple other policy changes that you've suggested.
I think one of the big, I don't want to speak for Cody, but he keeps bringing it up, and I think it is true, is that we made a decision early on to generally stick to what's in ROLCA.
Right.
In this particular case, this is a concept brought up, and I think that is relatively consistent throughout our discussions. So I think that's actually something I would lead to. You know, when we're talking about why we took on this project in the first place, I remember going way back, and the whole idea, even in the proposal, is that not being more in coordination with ROLCA does put Oregon as a disadvantage compared to other states that Oregon businesses, LLCs specifically, often interact with. So I think that could be an overarching, and because I do think something going on with Susan is very few of the legislators themselves are going to want to engage in the deep conversation that we're having. It's really these overarching details in case it gets flagged that this is a change.
Right. And I think
I think the other reason,
go ahead, Teresa.
Sorry. I think the other reason we're doing this is because we've identified some defects in the current policy in terms of relying just on majority and numbers. And that because the current policy is defective, we ought to be looking at a blank slate and considering the various policy choices and what we think expectations of the parties are in general and the desire to be consistent with the law of other places. It's the point of a uniform act, after all, that it makes sense to go with the default that's set in ROLCA, but of course people are still free to contract on their own to do something different. And so it's not a high stakes change in policy because people who want to follow the existing Oregon policy are still going to be able to do that. It's just changing a default rule. So it's not like we're changing Oregon's policy about deciding to have transparency, which I think was a big deal and a big policy change that there are a lot of people who felt very strongly about. I just don't think at the end of the day, when people that are forming LLCs thoughtfully can make a decision either way they want to, that this is a high stakes decision.
I agree with what you said, Teresa, and to put meat on it, it's kind of what Mosen said earlier in that comment in 1006 that says if it's unanimity, we don't need appraisal rights. If it's not, you need to add them. Well, that's the problem with our current statute. It's majority and it doesn't have the appraisal rights. So
And that's a policy
almost like
choice
there's
too.
a defect. There's like a defect that we're fixing.
Yeah, and so what I would suggest is that we have to make a policy choice one way or the other if we identify this defect in the existing statute. And from my perspective, it's much simpler and the ramifications are much fewer if we simply go to unanimous consent than if we were to incorporate a majority consent concept and then add wholesale new language about dissenters' rights that does not exist in the uniform statute or under our existing statute.
But we can steal it from Washington statute if we need the language. It's there. I found that.
And I think this, to me, the strongest argument personally is the one Cody has made, although I don't think it's the argument he meant to make, which is if we give here, then we can take more in terms of contractual freedom with respect to other aspects of LLC relationship, most specifically fiduciary duties.
I will just reiterate that I don't think we should water down the fiduciary duties, even with unanimity here, because there's other ways that people can.
That's what I took from it, Cody.
Okay, so
Where'd we end up?
so I think where we ended up with is, and I do think that we're going to have to do this generally when we present this to Sean, to say that, you know, to the extent that we are making a change. So we'll have areas where we've changed to reflect current Oregon law, specifically with respect to transparency issues. We'll have areas where the proposed act diverges from current Oregon law, and this is going to be one of them. And the reasons for that are our general policy decision to stick with ROLCA, where, you know, there isn't a compelling reason to move from that. You know, the fact that the majority in number issue is a problem, which I agree with. And, you know, that it reflects reasonable party expectations that if they're getting together and that, you know, they're going to make a major decision about the future of the entity. And I share your concern that you don't want to have someone holding a deal hostage, but, you know, you can amend their operating agreement prior to going into this if you have better language in the operating agreement saying they can do that. You know, and then it would be a bigger change to increase the fiduciary duties and grant appraisal rights. Does that capture everything? Hi, Kathy.
Yeah. And just to clarify, we're making this decision across all of these various transactions.
Yeah, so 1022 or yeah, 1023, 1033, and 1043.
Valerie, the only thing I would add is that should the powers that be decide that a majority is the better route, that they consider something other than a simple majority number, and that it be more of an economic or some other measurement.
I would say that's part A, Cliff. Part B would also adding in the appraisal rights, some minority rights if you go to majority.
Yeah, I mean, it's you open the can of worms when you go there at some point, right?
So it will be interesting from a drafting perspective if we go with unanimity, and because everybody's going to draft around that, at least in my view. Yeah. But then the question is whether it'll be best practices to include appraisal rights in your operating agreements.
Yeah, and I think that is a discussion that we're going to have with respect to how do you educate the bar on this, right?
Yeah. Well, it's a good point, David. And I wonder if some of us are going to be drafting some more of those just as an outlet where we have a dissenter in a transaction. You know, where, you know, I mean, we can certainly define the voting rights as well for these kind of transactions in the operating agreement. But sometimes if there's an off-ramp, that's explicit in the agreement. So I agree, Valerie, just, you know, things to remember when we want to be educating the bar about things they may want to look at in their operating agreement.
And I'll add, we're all better off if we leave appraisal rights to private ordering than imposing it on everyone by adding it to the statute.
Yeah, agreed.
At least that's my perspective.
Why?
Why?
Yeah.
because then people who want appraisal rights can opt into it and can craft whatever kind of appraisal rights they think is appropriate, as opposed to having a statutory rule that apply as a one-size-fits-all solution on all LLCs.
But then you leave the carpet layers aside because they're not going to be sophisticated enough to address that issue in an operating agreement.
If they're sophisticated enough to opt out of unanimous consent, which is the default rule, then they should be sophisticated enough to think about the ramifications of opting out of unanimous consent.
Yeah.
James, you need to have a talk with those folks at LegalZoom.
There's so many things you could discuss with the folks at LegalZoom.
Yeah, like how to practice law.
Yeah, or maybe yeah.
Okay, let's not go there.
Okay, anything
Keeping us all employed.
like what, Teresa?
They're keeping us all employed cleaning up their messes.
Oh, yeah, it is unfortunate for our clients to be in those messes. Okay, Mosen, back to you.
Okay. Well, I think that was a productive conversation. If not everyone was happy with the result, I'll note that my headpiece battery is dying, so I'm switching back between my two AirPods. So excuse me if I cut out. I'll have to go get the other one. Okay. So that. So I think we're still on 1033. Let me see if there's anything else that I wanted to raise on 1033 before we move to 1034. And the key issue was the unanimous consent issue. No, I mean, the only other thing I'll add, and I don't mean to open up the discussion we just had, is just do note that to the extent we go with unanimity in issuance interest exchanges, that will be inconsistent with what the corporate statute currently provides, which is majority shares would allow for an interest or a share exchange. Okay. Otherwise, the language here is going to be more or less identical to the language we've already approved with respect to mergers. So there's nothing else I think we need to talk about on 1033. So I'm ready to move on to 1034 if there's no further discussion on 1033. 1034 deals with amendments or abandonment of a previously adopted plan of interest exchange. And again, here the language is more or less identical to the language that we already reviewed in 1024 with respect to mergers under the RULLCA. And so I don't think there's really anything here that we need to look at too closely. The thing that we did discuss when we talked about 1024 was that we would omit, let me get 1034 in front of me here. We would omit Part D of 1024, and then for the same reasons, we would omit Part D of 1034. If you recall, Part D of this section deals with the improbable scenario where an LLC has adopted a plan of interest exchange, has already filed a statement of interest exchange, but before that statement goes effective, wishes to abandon the interest exchange. That's what Part D would allow for, and we agreed to omit it from the merger context, and so I think it makes sense to also omit it in this context for the same reasons. And I can't quite remember what the reasons were, but I think it seemed like kind of an unnecessary bell and whistle and an additional filing with the Secretary of State that we just wanted to avoid.
That's consistent with my recollection, but let me just take a look at my notes.
Yeah. Seems
My
to make
notes
sense.
was that we were concerned about a fiscal impact of this, and it wasn't worth doing it for that reason.
Right, the additional filing with the Secretary of State for something that is highly improbable and probably unnecessary.
Yeah.
Okay.
Yep.
Okay. So otherwise, this very closely parallels what we already saw in 1024, and so I think it needs to be conform to that. So the only change would be to omit Part D as we did in 1024.
Yeah, I'm fine with that.
Okay, great. All right, so that brings me to 1035. Again, 1035 is very similar to what we looked at in the merger context under 1025. And so whatever changes we agreed to there, I think need to also be made here. The principal change that I have in my notes that we agreed to in the merger context that I think we also need to bake into this is that with respect to parts A and B of 1035, we need to incorporate the concept that in addition to the statement of interest exchange, the acquired entity needs to also file with the Secretary of State its plan of interest exchange, or in lieu of that plan, a written declaration of where the plan can be found by the entity's equity owners. So that would just be modifying this to add that kind of conforming language.
And I think like the way we did it with 1025 would be essentially just to add as 1035 B5, essentially the language of RS 494 1B, modifying that language to use the ROLCA terminology.
Let me see how I have it in my notes. Yeah, it looked pretty straightforward, although as I started kind of getting into the weeds, I thought it might be a little bit more than that. But yeah, it's essentially that. The concept as I have it in my notes is that the plan of interest exchange or a written declaration of where it can be found needs to be filed with the Secretary of State alongside the statement of interest exchange itself.
Yeah.
So this is a concept. Yeah.
Jamie, do you have any concerns or thoughts about that?
I don't. I do agree that it should just be the same as what the merger is, so that they can give us an address instead of actually having to give us the whole plan.
Okay. Yeah, so it looks like it included 63,494.
1B is what I have, yeah.
Yeah, it's a sub 7. Yeah.
Sorry, can I get that section of the ORS number again? I'm having trouble hearing specifically what it was. It's 63
494
494 1B. Okay.
Otherwise, the language here is largely conforming to the merger of language that we looked at previously, but applied to interest exchange. So I don't think there's anything else to really do here. I don't think we have to talk about any specific provision further.
Nope.
Okay, great. So that brings me to the final section, 1036. And here again, this is similar to the language we looked at in the RULLCA's merger provisions, but a little bit different as well, because here the consequence of the transaction is different. We're not having two entities merge into one. The target entity survives as a wholly owned or typically wholly owned subsidiary of the acquirer entity, and so its separate legal existence continues. So the language is different there in that respect. But otherwise, this is very similar to that same language that we looked at in 1026 already. So I don't have any changes that I would propose to this language, given what we already approved for 1026.
I guess one and potentially two changes is for 1026 we had agreed to if I recall, my notes say we agreed to include the language from ORS 63,497 1H about the tail for partners in a general or a limited partnership.
Yeah.
Cody, I have in my notes that we agreed to just add in the commentary that particular provision, this is ORS 63,497 I, is that correct?
1H.
Oh,
no,
1H.
I have two comments. I have one about I, and then I've got another one about H. So I do have that we're going to make a comment about the language in I, but then I do have a note that we're going to add in the language of H.
Yeah, I thought we were going to add in H and have a comment saying we're keeping it because Oregon legislature made that policy choice in 97.
Right.
And that we were going to just have rather than having 497 1I, we were going to have a comment that is inherent in ROLCA 1026 day 5.
Okay. Yes. No, that's what I have as well, Cody. So let's talk about that. So first, with respect to adding the exception that's found in 1H.
Mm-hmm.
Okay. So the issue here is that with an interest exchange, the entity survives the transaction intact. All that changes is the ownership structure, the owners of the target entity. Okay. And so from that perspective, I don't see the need for that 1H language anymore, because we're not talking about going to a limited liability entity in which the owners might be protected from might be personally protected from the liability of the entity. The entity continues, and the entity's liabilities continue.
Yeah, and I think we look at the same issue in conversions. I mean, the conversion statutes say the entity continues. So I don't read it as, particularly if we're having a general partnership convert to an LLC and you have general partnership liability. I don't think the statute speaks to the extinguishment of that prior liability as general partners, because it says it's the same entity. So
Right. So with
not
respect to
ahead the same issue.
So with respect to both 1036 and 1046, then we probably don't need the 1H language.
That's my assessment, unless someone wants to convince me that I'm wrong.
No, I think that makes sense.
Mm-hmm.
Because what 1H is
Well,
really
the
trying to do.
Oregon conversion statute has this same exact language.
Yeah.
It's 463, 479, 1G. It's the exact same language about the general partner of a limited partnership.
It might be true for conversion. I don't think it's true for an interest exchange, however.
That part I don't, yeah, I mean, that part we can discuss, but it strikes me if we're keeping it for merger, we ought to keep it for conversion as well, since it's in in Oregon statute for both merger and conversion.
Right. But 1046 A1B says it's the same entity without interruption as the converting entity.
And that's,
Well,
I guess we can punt it for conversion.
Yeah, I think we're getting ahead to a discussion about conversions. If we're just talking about an interest exchange, I'm not sure this language is relevant. And indeed, I don't think it's necessary to include, because we're not talking about changing an entity from one type to another. We're simply talking about changing the ownership of an entity from its owners to the acquiring entity.
So I guess, yeah, just walk me through. Let's say that you're that supplier who does business with the general partner of the partnership.
Mm-hmm.
And all of a sudden that partnership does an interest exchange.
And is the target entity is being acquired in the interest exchange?
Let's start with that one.
Okay, sure.
So then the former, now that same person comes back into my store to buy stuff. Does the liability contemplated in this 12-month tail period under the RRS apply to that person who's come into my store?
If he's
under partnership law, I guess this gets into partnership law now. Under partnership law, the liabilities that existed prior to a partner's departure from the partnership continue to be that departing partner's liabilities. The departing partner doesn't walk away from the liabilities that existed in the partnership by simply withdrawing from the partnership. And so I think that still is the case here.
But we're talking about for a year after the merger occurs, that same person who's the general partner goes to that same supplier and buys goods. That general partner person is personally liable even though after the merger, there's no more partnership anymore. They're treated as if, again, this is assuming that the store doesn't know of the change, but there's this sort of protection for vendors who deal with general partners for a year after they stop being general partners for new liabilities. So I'm just curious, if there's that protection for in the merger context, I'm just trying to understand how is that not necessary in the interest exchange construct?
Because the partnership continues to survive the transaction. Although now, let me just finish the thought and then I'll add the complicating thought. The partnership continues to survive the transaction as a wholly owned subsidiary of the acquirer. Where this is confusing to me is you can't have a partnership with just one partner. So that partnership doesn't actually survive the transaction. It just becomes assets of the acquirer. I don't know. Now I'm getting to the limits of my knowledge. So maybe, I mean,
so we're at the edge of the universe.
Yeah, I know. I'm looking over and I don't know what's there.
No, you're right though, Mohsen. You're right though. If there's not two partner, it does. It essentially goes away.
So is the partnership dissolved and the partnership assets just become the assets of the entity that was the acquiring entity in the interest exchange? If that's the case, I don't know. I guess I need to think about this a little bit more. Where I'm kind of leaning is we could include this language because I think it's non-controversial. Well, it does have a 12-month tail. I don't know. I defer to the business, to the transactional attorneys about why this would be a problem.
Well, I think the last time that we talked about this, and I think it was in merger, there is the language at the end of G that's also in the merger version that says that and had not received notice of the conversion. So one way to fix the problem that G creates is just give notice to all your creditors of the conversion, or in this case, the merger.
Interest exchange in this case.
Or in this case, interest exchange, right?
Yeah.
But in all those cases, there's I don't know if an opt-out's right, the word, but there's a way to correct the path of the statute. Just give notice to all your creditors of the change, whatever it is.
And I'm inclined to follow where Jeff is going there. And I think having it in the statute it's instructive from a procedural standpoint, like Jeff is just describing, rather than having the statute sort of be silent as to this issue. So I guess I am kind of landing on keeping the ORS language.
Okay, so if we do it, where does it go? So with respect to 1026, the provision regarding mergers, we said that under 1A, or under 1026A4, we would note an exception to this language that essentially incorporates the concept we're talking about in the ORS. There is no analog provision in 1036.
Well, I think it could either go under, it could sort of be an exception. I mean, I would defer to legislative counsel on how they want to draft it. But, one idea would be in 1036 D2, where it says that person who had interest holder liability, that they don't have such liability for any new debts. And then you would say, except for, the language in the ORS section about the general partner. Like that would be one way.
Okay,
to do it.
I can be fine with that.
And so I would just, I guess, do the exact same thing in the 10, this other context.
That was D2 you were referencing, Cody?
What?
That was D2, D as in dog?
Yeah, 1036 D2, I would just have sort of, at the end of that sentence, except blah, 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 Oregon language.
Yeah, okay. And then, so that was the first issue. And I want to see if there's any further discussion on that before I come to the second issue Cody raised.
Oh, go ahead.
Okay, the second issue was that, let's see. This was with respect to adding a comment to say that ORS 497-1I is already covered in 1026. So we didn't explicitly add it in 1026, I think in A5, 1026A5.
Yeah, so I would just suggest doing the same thing again here as we did for 1026.
Well, so again, the issue here is there is no such language because we're not talking about fusing two entities into one like we are in the merger context. And for that reason, there's this language here that says that the surviving entity, continues with all these rights, et cetera. There's no surviving entity to discuss here. The acquired entity is the acquired entity. It was the acquired. It continues post transaction.
Mm-hmm.
And so, I mean, we could add the same comments here. I guess there's no harm. It's just that it's not obvious that that wouldn't be the case.
Well, because we don't have that subsection in this, right?
What about in conversion? There's a similar concept, although it's slightly differently worded. It's in 63-479-1H. Would similar language make more sense, or be desired, or a comment to this effect? I guess, would that be appropriate here? Something more along the lines of 479-1H.
Again, I don't think there's been no transformation in the business entity itself. So what merger and conversion have in common is there's a fundamental transformation of the business entity. Here in an interest exchange, you could think of this as kind of a sale of the ownership interest of the target entity. And so the target entity remains intact. What really changes is the ownership of the target entity. And so for that reason, I don't think there's any need for this language. Now we could include language like this as a commentary, which is the approach we took to 1026. I think in 1026, it maybe makes a little bit more sense to do that because there has been a transformation in the entity through the merger. There's been no similar transformation here in the interest exchange.
That makes sense to me. So just don't have anything on this topic.
Yeah, I think it can be counterintuitive if that were not the case for interest exchange. Now with the conversion, again, I think we do need to have this kind of language if we have it in the merger context.
Version, just so it's clear for Secretary of State, if nothing else.
Say that again.
I think in conversion statute, you need to add that section because the entity is transforming.
But Michael, you agree that in the interest exchange context, we don't need such language because the entity is remaining intact. And it's only
the entity remains intact. I suppose the one issue is if you have a partnership which requires two or more partners. If they all get acquired, I think you end up with a partnership dissolution. So I don't know how you reconcile all of that.
That was the kind of bizarre scenario that I was hoping to not have to deal with in the statute.
We're back in law school here.
Yeah. I never left. Okay, so I mean, other than that change, and thank you, Cody, for bring that up. That would cover 1036 and interest exchanges.
Okay, so that's all we have on interest exchanges. We have technically 20 minutes left on the calendar for this meeting. Do we want to get started on conversions?
Well, Valerie, can I suggest something? Michael and I conferred yesterday by email, and I'm going to take the first three sections and he's going to take the next three sections. But Michael sent me an email about a threshold issue. Michael, do you mind if I just read it? Maybe we just discuss that threshold.
And I was going to talk about that as well, but lead off.
Do you want to just go ahead and do it? I'm thinking, Valerie, you'll understand when we say it. It's a good issue to finish, and then we'll pick up with the specific statutory language next meeting.
Yeah, because my expectation is that it's not going to take us all that long to go through conversion, having already gone through the other two.
Yeah, it's really parallel language.
So I'm
not a lot of new territory.
Right. So Michael, go ahead,
Can I
Michael,
just
go.
finish? Jeff? Can I
Oh,
finish?
sorry.
So I'm hoping that next time what we'll do is we'll go quickly through part 4 and then get started on domestication. Because I think domestications will take some discussion. So the two of you and then James should be ready to go. I think next time would be my guess. Okay.
All right, well, Michael, put your issue on the table.
Well, the issue is really looking at ORS legislative history. When you look at some of these sub notes, focusing in on the legislation that really brought conversion into ORS for LLCs in 1999, Oregon Laws, Chapter 362. You can see the notation there. And you look at that act, and it really, for all the entities, brought in parallel structures. I mean, we can look at 63, but it's almost the same language when we look at ORS 60 dealing with corporations, 67 dealing with partnerships and LLPs, 70 dealing with limited partnerships, and even ORS 62 dealing with cooperatives. The act really added this parallel structure of both conversion and mergers, by the way, and used a common set of definitions.
Mm-hmm.
And so I think it's an issue that we could very well see legislative council raise. It's like, well, you're kind of disconnecting LLCs because if nothing else, just the definitional structure that ROLCA has is just completely different. You have these organic rules, private organic, this and that. I mean, it's just nomenclature that you don't see anywhere in ORS.
Right.
And frankly, I like the ROLCA language, but I'm just teeing up the issue from the perspective that are we going to get pushback from legislative council when they look at this, and we're taking one entity statute and kind of departing from what the legislature did in this 1999 act. That's the point.
Yeah, and I think that we had this discussion when we first started chapter 10, right? Because we had acknowledged when we started having these discussions that this was creating a separate set of words that are not currently used in other sections. And I think the discussion that we had a few months ago with respect to that was that you have to start somewhere. So unless we're going to do a big omnibus bill to, on 62, 60, 62, 63, 67, 70, we have to start somewhere. So there may be some reconciliation that needs to happen down the road. And I think that's a good thing to flag for legislative council. I don't know that
I think we should flag it, and you look at the Uniform Corporate Act that may be next on our plate. It parallels the ROLCA structure.
Right.
Yeah.
So that if we're going down that road, I mean, we have LLCs and corporations covered, probably gets over 95% of the entities that would be covered in most transactions. So I think we need to tee up the issue. I'm not saying, we don't keep going through ROLCA. It just, as I was looking at this and looking at the legislative history from this 99 Act and looking at what they did, I would imagine that legislative council is going to be doing the same thing.
Yeah, and I think that is really, Susan popped into existence. Hi, Susan.
I am around. The details are not always what I want to focus on. I think your point is really well taken, though, and thank you, Valerie, for acknowledging my hand raised. Legislative session is over, and I know Elsie's office is busy, compiling all the statutes and doing all that hard work, but it might be worth reaching out at some point in the next month or so. Sandy, I don't know what your thinking is, but to touch base with
Sean.
Yeah.
Because he needs to understand kind of what you're doing and your thinking and decision points. But Sean, as some of you may also know, is somebody who likes to create, he likes to be a big thinker. And sometimes he can take an idea and run with it. So it's really important for him to understand your thinking and where you're going. Because otherwise you're going to do a lot of work after he drafts something. You'll do a lot of work going back and saying, well, that's not what we really meant, or this doesn't really explain, this takes it to a different level, because Sean is a big thinker and he likes, I think this is a project that's important to him. So it's important for him to understand your thinking, and having him attend a couple of your meetings once his schedule allows him to do so would be probably a good idea.
I totally agree, Susan. I'll get in touch with him as soon as I can. I'll continue to try. He's been invited to every meeting. I've been very consistent about that. But yes, I understand. Thank you.
Yeah, and I do think that, to the earlier points, I think that we are going to have notes to Sean. It sounds like a terrible Nicholas Sparks novel, but we'll have to have notes to Sean that will, accompany this, that has some of these bigger picture. So this is where it's going thing, because I do think that the whole chapter 10 is I think probably better language from my perspective, but it is different language than we currently have in all these other sections.
I would agree, Valerie.
Okay. Well, I think that's probably a good place to stop, unless anybody else has anything further that they want to add.
Next meeting is on, I just looked this up, the 8th, I believe. Sorry, the 9th. It's a Monday.
Are we going to set the September meeting as well, or do we have that set?
I'd like to set a September meeting, if possible.
Sure.
We scheduled our next meeting for August 9th.
August 9th, yeah.
Okay. I won't be able to be there, but that's okay.
Are you going on vacation?
I am.
Good for you. I support that.
Well, I'll be coming back from it early too, but yeah.
Okay. Okay, so September, I am hoping to be in California on the 5th for my grandmother's 101st birthday. So we'll see.
Wow.
We'll see how that goes. So I could do later that week. So maybe the 9th, or I could do the following week.
The 9th works for me.
That works.
I can do the 9th.
So we do the 9th? Let's do September 9th.
All right.
And then I will be sending out a doodle poll. And actually, I'll also send out, when I send out the email, I'll ask if you'd prefer to meet in Portland or if you'd prefer to meet south of Portland, because we could find a place that is more, that is easier for the folks who are in Eugene and Salem to get to as well. Okay. Anything else for the good of the order?
Thanks everyone.
Yep. Thank you all so much. Have a great rest of your day.